You're an employer and you hired a F1 student who is on optional practical training, and you're trying to figure out how to keep them in the US on a long-term basis so that they can keep working for your company. Stick around and I'm going to walk you through the process. My name is Rahim Danani. I'm a US immigration attorney. I've been practicing US immigration law for more than 25 years. The first thing for students, they're mostly going to qualify for a particular type of visa called an H-1B visa. And that visa is for people who are working in a specialty occupation. So what that means is basically that the employer has a job that requires a bachelor's degree or higher in a certain field. For example, if you were hiring a mathematician, you would probably need somebody who has a bachelor's degree in mathematics or something that's pretty closely related so that they could do that job. The employer has to have a job that's in a specialty occupation, and then the student themselves have to have a diploma. They have to have graduated and gotten their degree in an area that's related to your job. So in our example, they have a degree in math to take on a job in mathematics. And once that's established, then you can move on to the process of figuring out, how do I file for an H-1B visa for this person? The first thing to know about the H-1B process is that there are only 85,000 H-1B visas available each year. There's 65,000 available for anybody who has a bachelor's degree, and it could be from any country, but it has to be equivalent to a US bachelor's degree. And then there's another 20,000 for people who have a US master's degree or higher. So a degree from a US institution, master's or a PhD, would fall into that additional 20,000 category. There's a total of 85,000 H-1B visas available each year. And usually what happens is there are more than 85,000 applications for those available slots. And sometimes it's 300,000 or 400,000 applications, sometimes more, sometimes less, for those 85,000 slots. What happens is the USCIS will run a lottery for those 85,000 slots. And usually what they do is they'll open up a portal in March, and you would submit an application for the H-1B lottery in March. And then if the application is accepted, then you would be eligible to file an H-1B full application for H-1B status, changing from an F1 student to an H-1B. There's definitely a timeline with this, and you want to make sure that you have everything ready to go so that in March, when the portal opens up, you're able to submit all the documents and file in March. If you're working with a lawyer, usually it's good to reach out to the law firm in January or February of each year so that the law firm has enough time to get your employee onboarded. And if it's the first time you're working with that lawyer, they'll need to do some onboarding with you as well. The earlier you do it, the better in most cases. If you wait till the very end in March, then a lot of those lawyers may be busy and not have the time to take on your case because they just don't have the resources anymore. All the paralegals and the attorney time are used up. So get that done early as a word of caution. So the next thing that you do is we go through this process in the lottery. Hopefully you get selected. The Immigration Service will let you know in April if you were selected in the H-1B lottery. The attorney would get an email, and as an employer, you would get an email as well, just saying, check your portal, and inside the portal you could see if you were selected or not. And then once that's done, assuming that the employee was selected, the attorney would work with you on how to go through the process of filing the full H-1B application. If the employee does not get into the lottery, then you're going to have to start looking at, is there some other visa category that they may potentially qualify for? Are they going to have to just go home? Or if you're lucky and they're working in a STEM field, science, technology, engineering, and math, and their degree is in a STEM area, then the student might be able to get an extension on that STEM optional practical training, I think the maximum is up to 24 months. So they may be able to file for a lottery application again the following year, depending on if they qualify for that STEM OPT extension. Let's say that the employee gets the H-1B. The H-1B is good for 3 years, and you can extend it for an additional 3-year period. But during that H-1B period time, if you are going to keep that employee even longer than the 6 years, and you're pretty sure of that, then you'll want to go through the permanent resident process. And that involves filing an initial application with the U.S. Department of Labor, and it's called a PERM application. It stands for PERM Electronic Review Management. That PERM process is a testing of the U.S. labor market. So you're going to have to run various advertisements in various types of media to see if there are any qualified U.S. workers who want the job. If there are U.S. workers who want the job, then the PERM application is not able to go forward. But if there are not U.S. workers who want the job, if nobody applies that's qualified, then that PERM would get approved and it would get certified. And then you could file for the next stage, which is the I-140 immigrant petition. But one thing to remember about the PERM application is, as of today, they're taking about 18 months to go through that whole process. If this person is on an H-1B application, you might want to start that at the point where you filed for the H-1B extension after the first 3 years. That way you have 36 months to get the PERM application approved, and it gives you a little bit of a cushion in case something goes wrong in the PERM application process. You could still maybe potentially file a second PERM application down the road and still get through the process while the employee is on their H-1B status without hitting the final 3 years and that 6-year maximum time limit for H-1Bs. There's a lot of timing issues with that PERM application. The earlier you can file it, the better for everybody involved. Then once that PERM application is certified, what you can do is you can file an immigrant petition on behalf of that employee. And for the immigrant petition, you now have to look at the U.S. State Department's visa bulletin. And when you look at that visa bulletin, it'll tell you, depending on what employment category you filed the PERM application for that employee for, it'll tell you if it's a first preference employment category or a second preference or a third preference category. There's a timeline as far as when visas are available. It's basically the place in line for that employee. It'll break it down based on the employment category, but it'll also break it down based on countries that are traditionally oversubscribed. So in the employment categories, it's usually India, China, and sometimes the Philippines, and you might see Mexico in there, but usually it's India and China that tend to be backlogged. And if they're backlogged, then you could only file the I-140 immigrant petition for that employee, get it approved, and then you're waiting for the priority date, which is the date that the PERM application was filed. You're waiting for that date to be current, and then you can file the adjustment of status application, which is the final portion of the green card application. And once the adjustment of status application is filed and approved, then the employee would get the permanent resident card in the mail. And so that scenario is if they're backlogged on the I-140 immigrant petition. But if they're not backlogged in the employment category that they're filing under, then you could also just file the I-140 immigrant petition along with the 485 adjustment of status application together concurrently and not have that long wait for the visa availability, and then USCIS would process that. Normally it'll take them several months to do that, but once it's processed, the employee would get the green card in the mail, and it would be much quicker than having to wait for a priority date. So generally, that's how it works. You have a student who's on F1 OPT, they've graduated, they're using the optional practical training for 1 year after they graduate, they're working for you, and you decide, I'm going to sponsor them for the H-1B petition. The H-1B petition goes through the lottery, it gets approved, then you file the PERM application, the PERM application gets certified, and then you can file for the I-140 immigrant petition and the adjustment of status application. Hopefully you're able to file them together at the same time, and then that student ends up getting their green card, and then they can work for you for an even longer time than the 6 years maximum on the H-1B. And one more quick thing to note about the H-1B 6-year maximum is, depending on if the PERM was pending for more than a year, you could extend that 6-year time. And then also, if the student is backlogged because of those I-140 immigrant petition priority dates, then you can also extend that H-1B in 3-year increments if they have that approved immigrant petition. That's the breakdown. I hope that's helpful, and I will talk to you guys later. Bye.